Hi, and thanks for joining me for this edition of Q&A, Legal Questions and Answers. Okay, so the first question we have today is, can I sue over potholes? A privately owned business in the area has over 30 potholes in their parking lot. One day, it was raining hard, I couldn't see them. I hit one, damaging my rear wheel and part of the axle. The owner reimbursed me $259 for the repair fee, but he hasn't done anything to fix the potholes. Can I sue? All right, so let's take first things first. You had damage to your vehicle because you ran into the pothole. Possibly, if the owner of the premises was aware of the condition, acted negligently, if you could establish that he owed you a duty of care and that he breached it by allowing the potholes to remain in the state that they were in, possibly you'd have liability. But we don't even need to get there because you have no damages. You said that it was $259 to repair the damage to the vehicle, which the landlord reimbursed you. Therefore, you don't have any damages and you don't have a successful or viable claim. Remember that in order to have a successful lawsuit, you need to be able to prove both liability, that's who's at fault, and damages, meaning money. Money damages, you need to be able to connect two of them and show and prove both elements. So in this case, you really can't sue because you don't have a case. You have no damages. Your damages were covered. And as far as suing him to fix the potholes, it doesn't seem as though you have any legal standing to sue him to fix potholes on a privately owned business, unless there's some other relationship that we're unaware of in the question. But no, you can't sue him because you have no damages. All right, next is my estranged husband's not making payments on a car loan. He has the car and I can't locate him. So this is a couple that's in the midst of a divorce, and the car's in both of their names, but she's primary on the car loan. The husband has taken the car. She can't get in touch with him. The only name or number that she has as a way of getting in touch with him is his sister. And the sister says, yes, well, I'll try to locate him, but she doesn't. The bank is calling her now every day because the car payments are past due and she can't afford to make the car payments. She doesn't make much money, whereas her husband does. She wants to know what she should do. She just doesn't know what to do. Well, first of all, this is one of those situations where you need to get an attorney immediately. You're not going to be able to be very successful in resolving this matter without an attorney. Remember, I'm constantly telling people there are things that you can do without an attorney. This is not one of them. You need to go get an attorney who's going to help you. What will an attorney do for you? Well, an attorney will be able to locate and attempt service if they file a complaint on your ex-husband or husband, because you're not really exes yet. And an attorney will also be able to help you with the divorce proceedings. So it's something you need to do right away. Aside from those two issues, you could have an attorney that will help you with respect to the car payments, with the car loans, with dealing with the car company. So there's not much that I would recommend you do on your own here, aside from get an attorney immediately. All right, next, mortgage filing. The question is, must I file a mortgage in the county that I live in or where the home is located? And what will happen if I filed it in a different county? Well, the simple answer is that you must file or record the mortgage in the county where the property is located. If it is filed in a different county, which is an odd situation because most often the clerk will look to make sure that it's being filed properly. But in the event that it is misfiled, you're going to have to re-record the mortgage in the correct county, and it's better to do it as soon as possible. And finally, can I sue for negligence on owner of apartment complex for knowing and putting my family at risk of fire? So what happens here is these people live in a two-family house or apartment, and they live above the tenant on the first floor who happened to be very old. Okay, so she was 80 years old, They say that she had a hoarding problem and that there was a lot of garbage and other debris in the apartment. But the question doesn't include any facts concerning whether or not the woman had ever had the landlord come in and say, oh, this is a violation of the health code, you've got to fix this, there's been no warnings. It doesn't seem as though the condition of the woman's apartment rose to a level where something severe had to happen. Now, putting that aside for a second, the way this fire started, which ultimately killed the woman on the first floor, destroyed her apartment, and the asker of the question, who was on the second floor, destroyed their apartment and belongings. They want to sue the landlord to recover the damages, but the fire broke out because the woman on the first floor had lit candles and had fallen over and set a curtain on fire. So, even if the house was a mess, even if there was a lot of debris and whatnot, the cause and origin of the fire were the candles that fell and ignited the curtains. So it is really, really unlikely, if not impossible, that you're going to be able to sue the landlord for negligence. The only negligence that you could potentially argue against the landlord is that he or she knew of the condition of the first floor apartment, warned the tenant, took steps to do something, or knew about it and did nothing. But even so, that's not the cause of the fire. So I don't think that there's any negligence on the part of the building owner, and therefore I think your only option is to go through your renter's insurance to try to recover damages for your property. If you don't have renter's insurance, you're going to have a problem. And it's a terrible thing, and I feel terrible for the person that has asked this question, that they've lost all their possessions. But at the same time, because it's a tragic situation, it doesn't necessarily mean that you have a legal cause of action. And in this case, I think it's impossible to establish a breach of a duty of care that is owed by the owner of the apartment to the asker of the question in light of the circumstances. So I really think you have a tough road to hoe, and if I were to be asked to take a case like this, I would say no, because I think it would probably constitute frivolous litigation in the sense that there's really no duty or breach of duty. So unfortunately, the answer is that no, you cannot sue the landlord. Well, I'd like to thank you for joining me today and going through these questions. If you have questions of your own that you'd like to submit, please do so. You can do so by submitting them in the comments field below. You could post them on our Twitter, on our Facebook page, or you can download our app, which is available exclusively for iTunes, from iTunes. You can download it for your iPhone and your iPads, and it has a really unique, neat feature. It allows you to ask an attorney in my office a question right from your phone or iPad. Ask the question, it'll be submitted to either myself or another attorney, and we will get back to you with an answer to the question.